that principle of legitimate expectation.
Okay.
So if you notice that you should levy these duties, the onus is now upon you to immediately do these assessments, post-clearance assessments, and issue that demand notice immediately. Don't wait after 3, 4, 5 years to come out and say, that Act allows you. So it's very, very interesting.
Yes.
So the courts are giving us, you can apply, maybe make a declarations, constitutional petitions, or judicial review. Some of these.
So there are also instances where are you able to maybe just take us through the steps of lodging a challenge on an evaluation and any cases that we've done and that we have won? You are not being fair to your member. And the reason why I'm saying that is your member has done his part. Okay? He lodged on time. Okay? The declaration is correct.
Yes.
But these governmental departments, are the ones who are causing the delays. At the end of the day, the matter remains between the clearing agent and his client. And the client is saying, no, I'm not responsible. So you're leaving your member vulnerable. What I'm saying is, why haven't we, as KIFWA, taken it up with the government based on our charter with them, that whoever is at fault will be held responsible? So that why would a customs officer be negligent in his work and escape, while the clearing agent is cornered for his own mistakes? And that's why I'm saying that I think it is good to look at this more broadly and be able to, and KIFWA must be able to put its foot down and say that when our members are declared correctly and on time, and there's a delay at KPA, there's a delay at KRA, at KFIS, and whoever is causing that delay, especially, for instance, where you have to go, like today you went to KRA on valuation, you won. What if it had taken a week? Now, if it had taken a week and you had 10 containers, what would be the demurrage that you would incur, all the storage that you incur? How does KRA compensate you for the faults of its employees? That's what I'm asking.
Thank you very much, Sina. I agree with you that many of our members are the ones who will be bearing the brunt of all these challenges occasioned by the respective government agencies. But you'll also realize that KIFWA has been quiet about these things. We really fought. For example, whenever there are these system downtimes, we've been on the neck of the government agencies affected to first of all issue that public notices to the members to have that done. Secondly, I think it's good there's a study that we did with you on the penalty to bond.
Yes.
From the study, you realize that the members who get affected mostly with this 3% penalty to bond, the reasons that are adduced on why these penalties were occasioned, they rest with the system downtime. I think there's a study that was done with GIZ, KIFWA, FEAFFA, 90%. But with this, KRA still goes ahead and penalizes. I think this is a challenge that, I agree, it's a challenge that is there. But another thing maybe we need to do, and KIFWA, we've started doing it, is on areas of sensitization. And I think the biggest mistake that the industry players have done is at times it is very difficult, for example, a commissioner or maybe KPA or whichever government agency to penalize their employee or maybe to compensate you. some compensation, you can just get them through the legal processes. I'm very much happy. If you look at the different sectors, people have taken advantage of this constitutional dispensation that we are having to pursue. There's some rights that it is very difficult, even if the commissioner want to maybe say, Mr. Kidenda, my employee, cost a delay for a taxpayer. Number one, the demurrage that the taxpayer paid, Mr. Kidenda go and pay. I think even then they will be acting out of the law. But if Mr. Kidenda, the taxpayer or the affected member went and challenged that maybe to the court and compelled them, then the commissioner will have a right to compel to compensate you. Another thing that many people have looked at, I was looking at the issues on whether the legal position on whether a government agency can penalize me for a mistake that is theirs. And it's very interesting things that have come. These are issues that haven't been litigated in the courts. And the courts are very much clear that where a problem, maybe it's a system problem, emanated from the government agency, then if they continue with that penalty, penalizing that person, then that is an unlawful exercise. So I believe and I think that our members need not fear maybe pursuing these through the judicial review, some of these matters even through the tax appeals tribunal. Lastly on this, the biggest challenge that I've also experienced with the members, you know, even if you were to pursue this thing through the legal means, you must rely on some documentation. So our members they need also to change, maybe apart from this raising of the complaints, if the office requests, kindly submit for us, maybe we need those receipts
proof,
for demurrage. At least it also helps. But again, computation of the costs and pursuing from the association standpoint.
Again, I'm just taking you back to the charter. We agreed that Kentred would be the arbiter in this matter, because we start the IDF with Kentred, okay? Every process that follows there, okay? And when we were proposing these things for the charter, we wanted like an independent party that can be able, because we are digital, okay? That can be able to print out and say that this is the history of this consignment. IDF opened on this time, okay? The entry was done on this time, okay? Downtime at Kentred themselves, okay? Downtime at KRA and all these other places. And I think that unless your office pushes it, okay, strongly, many of your members do not have even the money to pay to the lawyers, okay? But the small penalties that they pay because they are vulnerable, they want the business, they don't want to lose the client who gave them the business. KRA is too big for them, okay? Is there a way that maybe at intervals, KIFWA would be sitting with KRA and these other parties and say, look, all these cases, okay, this is what was incurred, okay, that our membership, okay, incurred, that needs to be refunded. Is that something that is worth considering?
I don't want to be like that person in the Bible. I don't know who this person was. The story Jesus said, who is this father? Whose child requests for fish
and gives him a
snake. I don't want to be like that. Maybe by being overambitious, or maybe making a populist statement in this podcast to tell you that what we can do. I think the biggest challenge that we've highlighted is that it's only in Kenya where we have around 45 government agencies intervening in cargo clearance. And these 45 government agencies, each and every one of them have their different legislations. We have fragmented legislations per government agencies. So even if the charter was to be affected and maybe a problem, for example, it arose, let's say, from customs, there is no way, there's no mandate, the legal mandate that KPA can use to punish, or customs to punish KIFWAs, because customs, they are governed with ECMA and the regulation of 2010. If you look at maybe KEBS, they operate, despite coming together as a community, a port community, they are all their mandate they get from the Standards Act. The 45 government agencies of them. So one thing that we've been championing for is that if we can have one uniform legislation that now encompass all the cargo players, all the government agencies and cargo players, I think that would be the quickest win to addressing some of these challenges. Then lastly, it is true that you can also get, maybe, you can go to court, pursue, and maybe get a judgment in your favor that the respective government agency offended your rights, occasioning that loss that you had. But you will realize that getting a judgment and effecting that judgment is the two different things. Like last year there was a judge by the name Professor, if I'm not wrong, that gave the people or the citizens the leeway that if I've gotten a loss as a result of specific government agency, and they have a judgment against them, then you are allowed to go maybe auction their properties. You quickly went and appealed that decision. Even if Kere were to be the ones you blame, and you get a judgment against them, there's no way you will effect that judgment. So those are the two challenges. But let's wait. Maybe the Court of Appeal will give a contrary opinion or support the findings.
Thank you very much, Fred, for the elaborate manner in which you have explained these things. We are having a break, and when we come back, we'll now go in to look at specific cases, court cases that we've handled that will enable our members to appreciate that it is that our laws still still function. If we take the right steps, we would be covered.
Thank you.
Thank you very much. Welcome back to our discussion. Today hosting Mr. Fred Aloo, the National Secretary of KIFWA. And at this time we want to talk about customs laws with particular reference to valuation. The challenges that our members face when they lodge their documents. Are you able to maybe just take us through the steps of lodging a challenge on any valuation and any cases that we've done and that we have won?
Thank you very much, Senior. I think matters to do with valuation, classification, among others. These are daily challenges that our members are faced with, but you realize that it's very difficult now to give a solution from the association's standpoint, because you realize that these challenges, they are more individual-based, and it depends with the documentation that each and every person presents. But from my experience is that this is a very, very big area of concern to me, because you realize that majority of the members, I think quite a number of us, maybe we normally do not know when I have a dispute on tariff or on valuation, what am I supposed to do? Number one, I normally urge people that ECMA and even the tax laws have given very clear and elaborate appeal mechanisms that one needs to take. If you look at section 229, it gives those process. For example, you're supposed to give an explanation. Maybe you are given values that you think are not accurate, or a tariff which you feel is not accurate. The law gives that provision whereby you can dispute that. And how do you dispute? You write to the commissioner, because all the officers, the proper officers, they act on behalf of the commissioner. So the commissioner is the person whom most of these disputes are channeled to, courtesy of the law. Write a dispute, and one thing that everybody must know is that if maybe you don't get a solution, the law gives you other channels. Tax appeal tribunal is also there, where you cannot go to the tax appeal tribunal, the courts are there. And one thing, timelines. Very, very much important when it comes to tax law. ECMA is very elaborate, Tax Procedure Act is very elaborate on when. Maybe you get a dispute, right? The commission is supposed to give you a response within 30 days.
Okay.
If maybe you feel dissatisfied, you have another 45 days to go to the tax appeal tribunal. And one of the things that maybe I would want to tell the members is if there's a tribunal that maybe many people have not given it more work to do, and which I think many people who are protesting used to visit, is a tax appeal tribunal. And it's very simple there. Maybe I'll engage you through the process.
Let me just give an example, and then you can take us through. So I've received a consignment of 10 containers of, let's say, telecommunication tower, okay, knocked down. And we did the IDF, okay, we gave that pro forma, okay, we got the IDF, the cargo has arrived here, and my entry is being rejected, and the customs officer is saying it's uplifting by another 3 or 5%. The grounds are that others are charging lower. But business is based on negotiations. It doesn't mean that the price that you get for your cargo from the same supplier will be the one that I get. How do I now proceed to ensure that I challenge this uplift, but also avoid the storage and the demerit that comes with the long time exchange between me as a clearing and forwarding agent and customs and my client who wants that cargo promptly?
Yeah, what happens in this scenario is that, number one, I'm normally very cautious when it comes to things to do with valuation, because I realize that as an agent, I'm not the one who bought these goods.
Yes.
But when it comes to classification, the agent must be very, very much.
Definitely.
You are the one who is now guiding the importer or the client on the correct tariff to use.
And you are an agent of customs also.
Yeah, you are the agent and you are trained.
Yes.
So what you need to do in this scenario, number one, I think the customs laws provide for this issue of release through bank guarantees.
Okay.
You write to the commissioner, have the consignment released as it pursues this dispute. The next thing that one is supposed to do is that at the customs station, there are customs now, the leadership, the hierarchy. So if it's a verification officer, for example, they have the HVO, the cluster manager, as you go up. So if you cannot handle this matter at the station, the provisions of the law allows you to now write to the commissioner, apply for a review of the decision that has been done. So as they do this review, the commissioner is supposed to give you a reason. But the biggest mistake that I've also seen that many of us make is that we do not know how do we write these.
How to write it, yeah.
If you look at is it Section 58 of the Tax Procedure Act, for example? I'm sure it's, I hope it's Section 58, on how does a dispute
letter,
what are the contents of this? It says that it must have matters of fact and matters of the law. So if you write a plain letter without giving any of the two, all the two, they know that those are review letters of the commissioner. We just look at them and automatically dismiss them, give you an objection letter. So ensure you have, give an example, if it is maybe a valuation matter, there's a very famous case, anybody who has dealt with valuation case, apart from the provisions of the fourth schedule, and there's also the testimony motors versus commissioner, Uganda Revenue Authorities, a landmark case that is almost applicable in most of these disputes. And once you can prove your value. And why the commissioner writes to you that your objection has been declined, the law still gives you an avenue to pursue this at the tax appeals tribunal. From the date that decision has been, you have like 45 days to prepare. So the thing that you need to do, just give the commissioner notice of appeal to the tribunal. Once you've done that, is that the tribunal, if you look at the Tax Appeal Tribunal Act, the documents that one is supposed to prepare, number one is a memorandum of appeal, so notice of appeal, the statement of facts on how to. So once you've had all these documents and you file them, within 14 days you're supposed to give your submissions. At the tribunal, the procedure there is more of inquisitorial. Inquisitorial here means they just make a decision, they interrogate the documents that you give.
Yes, it is.
Yeah, it's not majorly that you must appear there in person or through the adversarial court processes in courts. And one thing that the unfortunate bit, maybe to the taxpayer, but is an advantage to the taxman, is that the tax laws under Section 56 of Tax Procedure Act, they normally say that the onus to prove, the burden of proof is always on the taxpayer.
Yes.
Not the person who is alleging who is now the taxman.
Yeah.
I've looked at many cases, many decisions where the Tax Appeal Tribunal rule against the decisions that have been done here.
Okay.
So these are avenues that the law has provided that we should not make. Then at the tribunal, you can appeal as an individual.
So I think then the most important thing for the clearing agent is to be that knowledgeable and be able to convince the client, for instance, to be able to pay the extra, okay, pending the ruling, because keeping the cargo in port, incurring demurrage, incurring storage, and meeting the deadline for maybe the project far outweighs even the margin that. So I think it is important for our clients to be able to explain, for our members to be able to explain clearly to the client. Number one, give the client the assurance that you are on his side, that you are doing everything that is necessary to make sure that his best interests are taken care of. But because of the bureaucracy of the system, sometimes you'll be forced to just pay that extra. But do I pay it under protest?
Yeah, you can pay under protest.
Yes.
Or bank guarantee. I know bank guarantee might be a challenge to many of us.
Yes.
But you can do that under protest because now what the appeal process insulates you from being penalized with the offense.
Okay.
Maybe if a difference was, let's say, 2 million. Then you'll be penalized 1 million.
Yes.
So the law stops the commissioner in this matter now to penalize you until this appeal is heard and determined. And where you won at the Tax Appeal Tribunal, the law allows you now to apply for your refund.
So basically, when you are talking about the bank guarantee, we are not talking about the full amount. We are talking about a bank guarantee for the difference that is being asked. And I think that needs to be clear for clients and the clearing and forwarding agents, that you do not have to put the whole amount. You can say yes, because after all we pay upfront. Yes, I've paid the 18 million, okay? This 2 million, I'll give you a bank guarantee, but I'm paying under protest. Okay. Like
for example, and maybe another addition is that not all cases will require you to go to the tax.
Yes.
Tax Appeal Tribunal deals with two issues.
Okay.
Facts and the law.
Okay.
And where you are also dissatisfied with their decision, you can go appeal at the High Court. But another very interesting thing that the courts have also started on now the legality or the constitutionality of some of these decisions. I'll give you an example. If you look at ECMA, is it section 235, 236, and 134, the commission is allowed because the law presumes that the commissioner deals with very bulky consignments. And these bulky consignments, at times they cannot be in a position to check all these things at the same time as you clear them. So these provisions allow them now to go review some of these entries and maybe issue clearance. Demand notice. Maybe they say these were short levy duties. Paid, let's say, 100,000, but you're supposed to pay 200,000. So they demand the difference. And at the same time, somebody can also argue, I'm a trader. I made this declaration in the KRS system, the custom system, and while doing that, I was told I'm supposed to pay 100,000. I sold these goods at 150,000.
Okay.
I made a markup of 50,000.
Yeah.
So it gives me what a principle in law we call the principle of legitimate expectation. So as a trader, this 150, the 50,000 is my markup.
Okay.
Then 4 years down the line, commissioner comes to me that I'm supposed to pay this money. So it raises two very important issues of law. Whether the commissioner is right now to demand this money, and the taxpayer's right on legitimate expectation. And I'm very much happy there was a very key mark decision that was even given by the Supreme Court. The Kenya Revenue Authority versus Export Trading Company. And I think these are landmark decisions. These are some of the things that our members we need to acquaint ourselves and have some of this knowledge. Much as the court agreed with the commissioner of this very important right, but we're also saying that that principle of legitimate expectation. So if you notice that you should levy these duties, the onus is now upon you to immediately do these assessments, post-clearance assessments, and issue that demand notice immediately. Don't wait after 3, 4, 5 years to come back and say that the Act allows you. So it's very, very interesting. So the courts are giving us, you can apply, maybe make a declarations, constitutional petitions, or judicial review to some of these.
So there are also instances where you have been importing regularly, and you more or less take things for granted that the rates are going to be the same. And then, like in the recent case where now you are being told that the tax rate will be based on weight and not on value. What is your advice to our members on how to handle this? What is your interpretation?
My interpretation is that I think on this whole issue of the weight tax, I think this is a new phenomena which we are experiencing. I'm told, I think from December, where you're told you're supposed to apply some minimum weight tax. But when it comes to levying of duties based on weight, the law allows.
Yes, it does.
There are some, we have two types of taxes, the ad valorem or the specific.
Yes.
Specific taxes can be levied on weight. But what we don't agree with, what the law does not allow, imposing a minimum weight. If maybe today this laptop might be 4 kg. And maybe I know it does not attract a specific duty. And you're told that you must pay it on specific tax. But the minimum weight that you must apply is 20 kg. Then that is now unlawful. Even the law does not, from Article 210 of the Constitution, the duties, levies, or those licenses levied, they can only be done except where there is legislation. So
just face the KIFWA members and tell them this properly.
So I think maybe the members, these are some of the things that we need to interrogate. I think with things coming, we need a new paradigm shift when it comes on how we handle us. We are told we are the agents, both the customs agents and also the agents representing the importers. So we must ensure that the trader, let them pay the right taxes or a shilling less. The law also allows the commissioner to collect all the taxes that is due to the commission, and not even a shilling more or a shilling less. But these are some of the challenges that the office is very much ready to tackle, and we address some of these issues with them. And we should not all suffer in silence.
So now we want to claim. We want to claim. What is the can you just go over the appeal process again for your members to be able to appreciate that this is what I have to do as a clearing and forwarding agent when I'm making an appeal at the dispute? You've just gone through it, but I just want you to summarize it for our members.
So maybe let me, there are different, maybe appealable decisions, maybe customs, or maybe you wanted us to do with customs or the general, is it domestic or only?
No, just tax appeals. What is KIFWA's position on this? What is the advice to members?
I think I agree with you on the question that you put on mergers and acquisition. I agree that this is a very interesting area that maybe people need to, our members need to consider. For example, I'll give you like KIFWA, for example. We normally engage through mergers with other entities globally on some specific issues or objectives for the benefit of the members. And on the individual companies, I think this is also an area that we need to consider. For example, you see the very big giants in the logistics sector coming up to merge so that they have a bigger strength in this logistics chain. So I agree with you, but the challenge is that as KIFWA, the responsibility that we can have is just to preach to our members of the need and the importance, and now the issue on whether they will consider that lies on them. But I'm very much happy in the several fora that we've had, you've taken this issue so strongly, and I would maybe urge you as my senior that continue educating us more on this. I normally believe that when my terms of wisdom run dry, I must always run to you and other elders.
I think it is something that really we all need to consider, because at the end of the day, we need to survive.
Very true.
And we would only be able to survive when we are holding our hands together, not when we are pulling apart. So I think it is something that both the small and the big we'll have to consider, because otherwise there's the question then of cutting it into smaller pieces, and that is why people also talk about undercutting. And maybe you can comment on that also.
I agree with you, and then maybe on the mergers and acquisition. There was a challenge that was noticed previously, where maybe entities could come, they merge, they come through these merger and acquisitions with an intention to prevent, to restrict, or to lessen competition. So I think maybe in as much as our members also consider this avenue, if any of these mergers has an intention of restricting, lessening, or preventing trade, then you'll also find it is an unlawful act against the competition section 241, and it is heavily penalized. So let these mergers come to build strength.
Yeah, but I'm challenged on that. I'm challenged on that in the sense that we're very good at keeping the load to the extent that we die. Because it is happening all over. You see, when you talk about, for instance, I happen to have been a former managing director of Kenya National Shipping Line. Now I hear people talking about Kenya National Shipping Line being revived. But those who are talking about Kenya National Shipping Line being revived, do they consider the trend in the market today? Would Kenya National Shipping Line remain competitive against the likes of MSC and the rest of the people? Okay, I think sometimes that's a misplaced thing. But what you can do is you can get into mergers so that you get into that market, okay? Or else you have to mobilize the right size, okay? And maybe specialize. For instance, instead of doing the cross ocean movement of cargo, maybe Kenya, Tanzania, Mozambique, South Africa could have their line that goes around, so that they have also a role in that logistics. Okay, but as it is today, because of those mergers, okay, the companies that KIFWA members were apprehensive about when KIFWA was being informed are getting bigger and bigger, okay, while the brethren continue with their small outfits. So what are those people doing that we are not doing? For me, that's the question that what is the indigenous Kenyan business person that is running a successful business today, thinking of in the future, number one, in terms of succession planning, two, in terms of getting the synergy and the strength to withstand the very tough competition that is going to come with the Africa Continental Free Trade Area. When you will find that the Ghanaians are also here, when you'll find that the people from South have come here, how will you survive unless you have the right capacity to handle? I think
in agreeing with you, maybe I summarize that into number one, with a saying in Kenya, that he who does not travel, they normally think that their mom is the best cook.
Yes.
So I think this is also an area that maybe we need to consider.
Okay.
Maybe cross-border marketing would form a very bigger part, maybe to the members to consider. And then number two, there's something called comfort zone. It's a very nice place to be, very dangerous because there's no growth. So we need to come out of our comfort zones and maybe have such kind of concentrations.
Yes.
And the good foresight. I agree with you.
And you see, you need capacity. I remember going to Tanzania, and one of the clearing and forwarding agents was very vehemently against clearing and forwarding agents from Rwanda, from Uganda, and coming and setting up in Dar es Salaam. And he gave me a very interesting reason. He told me that if God wanted Rwandese to be clearing agents in Dar es Salaam, he would have put Rwanda next to the ocean. Okay. Now, it is good to imagine that God gave it to you, but God gives us for the good of all other people. So for me, what I'm thinking is that the more we are, the smaller the piece of that cake that you're going to have. Okay. Whereas if there were mergers, the East African, the FEAFFA members, should be promoting that general comradeship, between the clearing and forwarding agents in Kenya and those that are in Rwanda, those are in Uganda, and creating strength. Because why would you want to, for instance, go and open a full office in Uganda, employ more people there, when your friend with whom you are even in a committee in FEAFFA is also running and trying to run an office in Mombasa from Kampala? What about you merging? What are you then merging with the friend in Rwanda, so that you are able to give service? To let me look at a particular clique that you should look at, the diaspora. The diaspora all over who are sending their things back to Africa, and they do not have any good representation, here. So that's what I'm saying, mergers and acquisitions, or agency agreement in those networks that will give the indigenous investors the strength to endure. That's what I'm saying. Now, tell me this thing about cutting costs. How do you undercutting? How do you address it?
I think undercutting is a very, very big challenge that we are witnessing in the industry. And there's one of the members approached me with a very big tax dispute from the domestic tax department of KIFWA. And what this person was telling me that these people went through the bank statement. They saw that how could an clearing agent have 50 million Kenya shillings deposited into their bank account, but what they're declaring as their income is just 50,000 shillings. And they couldn't maybe understand. But you'll come to realize that this is a very big challenge, maybe on us, and it's a challenge that we are grappling with. Because today, somebody would, an importer, a client would come to you, they're very much ready to pay even 100 million shillings taxes to carry. They're very ready to even pay 2 million shillings to the shipping lines, to port charges, and the rest. But they cannot pay you. They cannot even pay you.
If you
tell them the percentage wise, you want to say, no, I can't pay more than 50,000.
Yes.
So I think you realize that the challenge is not with these clients per se. the challenge rests with us, because somebody will say that if how much is Kidenda charging you?
Yeah.
They come to your client. How much is charging me 100,000? Give me, I'll charge you 60. Or how much is he charging you? 15,000. I'll charge you 7,000. So this undercutting, I think, is a challenge that emanates from our members. From us, it is a sin within us that needs our own personal confession and effort to eradicate. However, there are attempts that, as an office, we tried maybe to bring it a few years ago, maybe gazetting the minimum rates that was supposed to undertake, and unfortunately, that breached the competition law, section 21 on restrictive trade practice, whereby the competition authority's argument was that issues to do with price fixing is unlawful and not supported by the competition law. So what ought to happen is the market forces to take its course, people to charge, so that competition becomes is not lessened or restricted through that. So personally, I've thought of maybe 2 or 3 solutions that we can canvass and maybe have this thing addressed. And number one, to address the undercutting issue, I think having undergone that experience with the Competition Authority, the provisions of the Competition Act allows an entity to write to the Competition Authority and requests to be exempted from this restrictive trade practice. And the reasons that are given, number one, they can only grant you 3 reasons. Number one, to improve the quality of goods and services. They can allow you on the grounds of earning forex exchange. And number 3, on grounds that the Competition Authority might think that it suffices. I'll give an example. If we had an act, if we had maybe the rates, the gazetted rates, on what we charge as clearing agents or customs agents for that matter, the government could gain. And number one, if you look at, I've not maybe done an analysis of the last financial year, but for the year ending 2023-2024 financial year, if you look at the total CIF of business that was undertaken, then suppose maybe we had a special rate of 1.7 billion, sorry, of 1.5% of the CIF as our agency fee. And from the projection that we were getting, the government could have earned by around 18.8 billion shillings more in terms of, as opposed to what they earn from the clearing companies as an income. So I think that's an area that we can explore, and the leadership, I think, needs to take it up urgently. The second issue, I think we have the bill. That is now one of the objections that bill is to have the minimum standard pricing that will be applicable to all the members. So the bill needs to be fast-tracked. And lastly, maybe the third avenue, the government nowadays comes with the finance bills. If we just extracted the minimum standard pricing from the bill and convince the Treasury on how we can maybe effect that through the finance bill, and the government can legislate, because these are ideas on how the government can earn more money. So I think these are areas that, if employed, we'll be fighting this problem of undercutting. So that tomorrow, for example, I'm not saying maybe that is what we charge. If you say, for example, tomorrow, the minimum agency fee that we're supposed to charge for an air freight, it's, let's say, 10,000 shillings, or a minimum of 1.5% of the CIF, or whichever is higher. And you charge less. So the orders will now be upon the person charging less or undercutting, maybe to now fight with KRA on that matter. Have you checked how the other associations work? I mean, because we have the lawyers, we have the architects, we have the doctors, we have the quantity surveyors association. Are they charging minimums? With the lawyers, I think the advantage that they are having is that they have an act of parliament. There's a time I was having a discussion with some guys from Competition Authority, trying to now make a comparison. What is it wrong with what we wanted to practice and what the lawyers charge? And their argument was that, for lawyers, their fees is dictated by the advocates' remuneration order.
Yeah.
So you cannot claim now Competition Act is superior to advocates remuneration order.
Yeah.
The accountants, I'm not sure. Neither am I sure with the architects. But what I know is that any entity that does not have various charges, either exempted by the competition authority or put in legislation. If you are to issue such a notice to your members, it will be against the Competition Act.
So you would say that when you are now talking about the KIFWA Act, all those things have been taken into consideration, and we still feel that there's room for us to have a minimum charge. Is that what you're saying?
Yeah, I think that's we needed a minimum charge. Okay. Like yesterday.
Okay. Then how do you then guarantee service delivery? Because at the end of the day, okay.
No, I think maybe
what is our act saying? If I came and gave you my consignment to clear, okay. So you're charging me a minimum charge, okay? And I have a complaint about your service. How do you go about it?
Yeah, I think number one, you cannot come up with a minimum charge if you've not professionalized yourself. So one of the things that even the bill was addressing was first of all having what we call professionalism within us.
Okay.
Yeah, we first of all professionalize. Once you have professionalized, so a professional entity are entitled to come up with those now charges because the minimum charge that you give will be commensurate with the service that you are rendering.
Okay.
So it's not just a one-dimensional issue of just focusing on the minimum fees that we're charging, but the level of professionalism. Okay. And I'm very much happy that if you look at even the projections of even the records or the data from Kenya School of Revenue Administration, quite a number of our members have taken this route of professionalizing. Because I know you might come from a different maybe background, educational background, maybe in commerce or maybe architect, but you want to venture into this. But I know the bill, the entity or the minimum yardstick that we had put was the training that we give in collaboration with the Kenya Revenue Authority through KIFWA. Okay. Yeah, as the base minimum.
Thank you so much. I think this will bring us to the end of our discussions for today. But before you leave, I want you to know that my next guest will be Mr. Sam Njoroge, former chairman of KIFWA, in fact, the inaugural chairman of KIFWA. He'll be coming here. And I'd like you to ask him one question. What question would you like to ask me to ask Njoroge when he comes here?
I think very much, though you gotten me flat-footed, I did maybe prepare with a question that you could ask Uncle Sam. But maybe when he comes, I think that he has been in the industry for long, and we really appreciate the good work that he did to the association. I know he was chairman when I think I was still in school then. Yes. But I think the good things that maybe he did, I will still see. Okay. So maybe ask him what did he do right? Okay. That as the current leadership.
Yes. I think one of the questions that maybe I might even put across to you is that when Sam's team handed over to the next government of KIFWA, they left a very healthy bank account. I'm hoping that trend, will be built into the legacy of every office that comes through. And of course, they did not do it on their own. The members contributed, but the fidelity in using the resources of the organization is very important. Thank you very much. This is Mr. Fred Aloo, the National Secretary of KIFWA, MD Blue Dot Logistics Limited. I'm very grateful that you found time to be with us here. Viewers, we are very grateful that you're supporting our podcast and watching. Please like it and subscribe. And we'd be happy also to get some of the questions that you'd want us to be posting to our people who are coming here. So next week we will be interviewing the inaugural chair of KIFWA when it was started. Thank you. God bless you.